The Independent National Electoral Commission has excluded the name of the candidate of the All Progressives Congress, Timipre Sylva, from the final list of candidates ahead of the November 11 governorship election in Bayelsa State. Now, the amended list, which was uploaded on the Commission's website on Tuesday, was signed by the Secretary to the Commission, Rose Oriarong Anthony. According to Oriarong Anthony, the action of the Commission was in obedience to court orders on the lists served on the Commission. Recalling that the Commission published the final list of candidates for the 2023 Bayelsa State governorship election on June 9 in accordance with the provision of Section 32 of the Electoral Act 2022 and the timetable and schedule of activities of the election, she said after the publication, INEC was served with an order of court in respect of the nomination of candidates of the APC for the poll. On October 10, the Federal High Court in Abuja disqualified Sylva from participating in the state governorship election. Now, to discuss this, we're joined by Barrister Vincent Otaokpukpu. Good afternoon, Barrister. Thank you so much for joining us on News Central Now.
Good afternoon, Paul. Thank you for having me.
It's a pleasure. Now, Barrister, can you explain the legal basis for excluding Timipre Sylva from the final list of candidates?
Yes, you have quite rightly said that the Federal High Court, upon a suit brought by one Killemore, a member of APC in Bayelsa State, who contested the eligibility of Timipre Sylva as the candidate of APC to participate in the election at the Federal High Court. And the Federal High Court, after listening to parties and gave judgment disqualifying Timipre Sylva from participating in the election. And I'm aware too that an appeal has been lodged against the judgment of the Federal High Court under Section 242 and 241 of the Constitution. Now, that being the case, I'm also aware that an application was made for stay of execution of the judgment of the Federal High Court pending appeal. And I think I was told, though I have not verified it, that the Federal High Court had refused the application for stay of execution. Now, when an appeal has been lodged against judgment of a court in this instance, appeal does not operate as a stay. When you look at Section 17 of the Court of Appeal Act, it says that an appeal under this part of this act shall not operate as a stay of execution. But the Court of Appeal may order stay of execution either unconditionally or upon performance of such condition as may be imposed in accordance with the rules of the court. So suffice it to say that filing of an appeal does not operate as a stay. But in our judicial balance, in our legal practice, parties are always advised that once appeal has been entered, the status quo must be maintained. Now, what is INEC has done by removing his name from list of persons who are qualified to contest the governorship election is well founded and is backed by order of court. This is the judgment of the Federal High Court.
All right, Barrister, now you might actually think so, but others, have a different opinion to that. But in all, how does this particular situation impact the overall fairness and integrity of the election process?
Yes, the fairness of every election process must be rooted in judicialism and constitutionalism and legality. And a dispute has been brought to court, and the court has given judgment disqualifying a fellow. Now, the fellow has gone on appeal. We wouldn't say that what INEC is doing is will succeed at the end of the day. Appeal court is seized of the matter, and the final analysis they will give judgment either in favor or against. But as it remains now, Section 184, subsection 13 of the Electoral Act says that INEC, where a political party has failed to comply with the provisions of the Electoral Act in the nomination of candidate to election, INEC has power to disqualify such candidate. In this case, INEC is properly backed by a judgment of a court of law. So this is well founded. Now, the dispute that has been brought before the Court of Appeal, I wouldn't want us to delve into it as to oath of office or no oath of office, and whether he can take off oath of office three times, because the dispute is that he took oath of office in 2007, he took another one in 2011 or 12 or thereabout, and by simple permutation or computation, if he allows to contest this election for another 4 years, he will be extending it beyond what the Constitution has stipulated for 2 terms of 8 years, which the Supreme Court have
Okay, we lost. Okay. All right, welcome back. So now, still talking on this. Now, you did talk about Timipre Sylva, filing an appeal and not being sure if he would actually succeed. But in the case or in a situation where he doesn't win the appeal, are there any legal or other legal remedies available to Timipre Sylva or the All Progressives Congress?
After the judgment of the Court of Appeal, either way, there was the party, they will say have to forum to approach the Supreme Court under Section 235 of the Constitution. The Supreme Court being the final court in the land. So these are the legal options available to him. But as it stands now, a judgment of the Federal High Court, which is subsisting, every judgment of a court confers on a successful litigant some right, benefit, and interest. They must have clothed the person. So whether there's also a dispute whether the Federal High Court is properly considered to even look at the matter, which is also before the Court of Appeal. But the cases are settled by the Supreme Court on this issue. In the case of P2B versus INEC, that issue that has to do with constitutional interpretation can be entertained by the Federal High Court under Section 251, subsection 1, R, and H of the Constitution. When it has to do with constitutional interpretation, Supreme Court Federal High Court can entertain it under the law, because the opinion has been canvassed against it that it is a question that has to do with the nomination and of Receiver. It ought to be entertained at the Election Petition Tribunal, being an action that has to question his nomination. But when you look at Section 84, subsection 14 of the Electoral Act, Section 29, C56 of the Electoral Act, and Section 285, subsection 14, 1 A, B, C, and of the Constitution, you agree with me that the dispute subscribed and consecrated under the above reference sections of the law are disputes that has to do with a candidate of a political party challenging the process of nomination or as the case may be. In this case, a fellow went to court. He was never a candidate at the primary election that nominated upon which Sylva was nominated, to say, court, interpret section.
All right. Thank you so much, Barrister Vincent Otaokpukpu, for joining us to discuss this particular issue at this time.